Let's carry on with the clause-by-clause scrutiny of the bill. We have covered page 13. Members, if you have any questions. After the registrar as well as the law draftsman finish on a certain page, then please press the request to speak button. No questions from members for page 13. Let's move on to page 14. Registrar, please. This is to amend section 11. Section 11, subsection 1. The period for giving notice will be changed from 2 months to 28 days. How about English version, textual amendment only? Page 15. We're amending section 12 here. We're introducing section 12, subsection 1G. In the course of dissolution of a trade union, if the general interest of the members of the trade union have not been prejudiced, but the registrar is of the view that the interests of the members have been prejudiced, then the trade union may lodge an appeal. English version, textual amendment only. There are other miscellaneous amendments, for example, the part about the date on which its registration is cancelled. Well, they're all textual amendments. Alright, let's move on to page 16. Registrar, please. Page 16. We're introducing subsection 3 here. If the dissolution of the trade union is registered by the registrar, pending the determination of the appeal, then the appeal is taken to be dismissed. The rest of them are textual amendments. Same for the English version. Let's move on to page 17. Registrar, I'm doing it page by page. Let's finish the whole page before we move on to the next. So page 16, section 12A. We are adding a new title, Division 4, Appointing Manager Pending Determination of Appeal. This is before section 12, capital letter A. There are no pure English amendments because this is a new provision. Page 17. This is also about appointing manager. 12 capital letter B. The registrar may appoint manager pending determination of appeal and take over the management of the property of the trade union. Page 18. Is the continuation of section 12 capital letter B. And section 12C is about the powers of manager. There aren't any pure English amendments on this page as well as the coming few pages. Mr. Chao Xiu-chung. Thank you, Chairman. Page 18. Bracket 5. It says the manager of a trade union may sell or otherwise dispose of the property of the trade union. And a general meeting has to be held in order to do so. Say there are members who are opposed to the disposal of the property and call on other members to boycott the general meeting. Or there are other members who call on the others to vote against the disposal of the property. Would that constitute the offense of obstructing the discharge of duties of the public officer? This is about subsection 10. It's about obstructing or preventing a manager from performing the functions of the manager. I'm referring to section 12 capital letter C, subsection 5. That's page 19 of the Chinese text. Subsection 5 is on page 19. Section 12 capital letter C spans a few pages. Maybe I'll wait until the registrar comes to this part to raise the question. Let's finish the whole section 12C, registrar. Thank you, Chairman. I thank Mr. Chow for the questions. Now, on the powers of the manager. The manager is to take over the management of the property of the trade union. Bracket 4. Subject to subsection 5, a person must not sell or otherwise dispose of the property of a trade union when the appointment of a manager of the trade union has effect. Subsection 5. The manager of a trade union may sell or otherwise dispose of the property of the trade union if the manager considers it reasonably necessary to do so and is authorized by secret ballot of a majority of the voting members present at the general meeting to do so. If members of the trade union are of the view that there is no need to sell the property, then the interest of the members will have to be taken into consideration. What I meant is that the manager tries to call for a general meeting and someone calls on other members to boycott the meeting or obstruct the meeting or try to stop the manager from selling the property. Will this constitute the offense provided for under subsection 10? Registrar, Secretary. If the manager thinks that there is a need to sell the property, the manager will explain the rationale behind to the members, and the manager will have to hold a general meeting to do so. I think it won't constitute the offense of obstructing the manager from performing his functions. Mr. Lai Tong-kwok, I thank Mr. Chao Xiu-chung for raising this question. Here is my view. The point of subsection 10 is about the manager performing his functions. Anyone who unlawfully obstructs or prevents the manager from performing his functions, it would be against the law. Subsection 5 says that if the manager finds it reasonable to sell the property, then he can call a general meeting and have members vote on the decision. Members will either support or oppose to the decision. The manager is given the power under subsection 5 to hold the general meeting, and the manager will have to get at least half of the members' support before he sells the property of the trade union. Say I am one of the members and I do not like the decision. I ask others to vote against the decision. At the meeting, I will have the power to vote against the decision. I may convince others to stand at the same position. This is my suggestion or comment. Section 12C consists of 3 pages. Any particular amendments to the English version? No. Now we come to page 21. Well, I'd like to first supplement on Section 12C. We've scrutinized the provisions just now. The government has reviewed the provisions, and on Section 12C bracket 6, we'd like to propose a committee stage amendment. Currently, it says a sale or disposal of the property of a trade union in contravention of subsection 4 is to be regarded as invalid. We have reviewed the provision. If the trade union has got a genuine buyer, then there could be an exemption. If there is a genuine buyer, then the transaction will not be regarded as invalid under the premise that the property of the trade union is protected. However, there will have to be a genuine buyer of the property. That's a CSA that we propose. Now, bracket 9G, it says the registrar may refer any subject of dispute between a manager and any third party to arbitration subject to the written consent of the third party. We will propose a technical amendment. We will add in the phrase mediation or referred to mediation. Please finish section 12D as well. It's the interpretation of Division 5 of Part 3. It says the property of a trade union covers books and documents.
Anything in the English text? Nothing. Mr. Emmanuel. With regard to 12C F1, they may convene a meeting. So I'd like to know whether that is for the disposal or the management of property. So can a general meeting of members only deal with this agenda item, or can the manager deal with other matters related to the trade union? Yes. You talk about section 12C. 1F. Convene a general meeting in accordance with the rules of the trade union. I'd like to know whether that general meeting can only confine to the management of property. Registrar? Perhaps I try to respond to Mr. An's question. Section 12C1. During the period of appointment, a manager can convene a general meeting in relation to the following matters. I get that, but then what can the general meeting discuss? Can it be related to matters other than the management of the property? Because that manager is appointed to manage the property, so can a general meeting deal with matters other than the management of the property of the trade union? I just want to have this point clarified. The function of the manager is to manage the property of the trade union. So I believe the general meeting should be convened mainly to deal with the property of the trade union, and if it is a related issue, I believe it can be addressed at the meeting. All right. Then can we go to page 22? Page 21. So starting from 12D all the way to page 23. They're all about section 14. Yes. This amendment will add under 14C, that is, after dissolution of a trade union, reasonable steps related to dissolution can be taken on. So the things that follow after the dissolution of a registration can still be handled. This is to empower the trade union members to deal with such things, and other amendments are textual in nature. Pages 22 and 23. There are two amendments in the English text only, and it is to replace the term thereof. Okay. Page 24 and 25. They are all related to section 15. All the way to page 26, Registrar. Thank you. Section 15, the amendments are miscellaneous. We don't have any new provisions added. So the whole section 15 only have textual and miscellaneous amendments. Law draftsman, again, gender-specific terms are replaced with neutral terms. Okay. That is section 15. Now we go to page 27. The whole page is on section 16. Registrar. Section 16. The amendments here are again miscellaneous in nature. All right, 3 points. Despite property, and what about the English text? 16A, just an update, textual in nature. Section 17 on page 28 through 30. Section 17. Ms. Butt. Yes, here Section 17 is amended. We are going to add Section 17(1)AA. That is to allow a person who is ordinarily in Hong Kong and engaged in or employed in a trade industry or occupation with which the trade union is directly concerned may not become a member. And then we've also added 17(2)A on page 29. That is to prohibit anyone who has been convicted of any offense specified in Part 1 of Schedule 1 to be a voting member or an officer of a registered trade union. We're also going to amend 17(3). A person who has been convicted of any offense specified in Part 2 of Schedule 2 must not, within the period of 5 years from the date of persons, sign as a voting member or be an officer of any registered trade union. We are also adding 3AA for persons who have been convicted of a specified offense. If the conviction is squashed, then the restriction on being an officer of a registered trade union or sign as a voting member can then be squashed. Page 30. That is to raise the penalty for breaching the provision on prohibition of being an officer of a trade union. Law draftsman in the English text, again, we have replaced terms like he and she. We've also got new 17AA on the right-hand side of page 30. This is to require officers of trade unions to notify the registrar of specified charges and convictions. So both charges and convictions must be notified to the registrar. Our legal advisor has also got a question. Legal advisor. Yes, before I mention the question, may I remind members that in the beginning of Section 17, there is a new addition, Division 1 Officers and Members as a heading. In relation to new Section 17(2)A, we have written to the administration on this part, because the legal consequence is quite severe. According to the administration's reply, that person will be disqualified from being a voting member of a trade union for life. But here, 2A, we'll talk about a person who has been convicted of an offense related to national security. There is no mention of the severity of the offense or the background or the reason for that conviction. And the other person will be banned for life from becoming a member or an officer of a trade union. So perhaps the administration can explain how this will satisfy the principle of proportionality. Registrar, thank you. Assistant Legal Advisor and Chair. We have considered Section 17(2)A. We believe this is in line with the Hyson Hing Yip case. In our response, we have already mentioned that whether the restriction added is of a legitimate reason, our intention is to enhance or to further safeguard national security and to prevent people with ulterior motives to become member of trade unions and to carry out illegal activities. Under the basic law and relevant international human rights conventions, we are allowed to restrict the right of freedom of association, and whether it is related to the purpose. Now, if someone who has endangered national security will not be allowed to become a member of a trade union or an officer of a registered trade union, we believe that there is a very strong logic for imposing that restriction, and whether it is really in line with the principle of proportionality and not too severe. We believe it is the case because it is a serious offense to endanger national security, and we have seen people with ulterior motives who wanted to engage in sedative activities under the guise of setting up trade unions. It would endanger national security. It would also disturb public peace, and this is an appropriate restriction we can impose on. And 17.2a would not allow a certain person to be an officer or the promoter of a trade union. Still, he can be a member of a trade union and he can vote in on matters of a trade union. And whether the public interest obtained from such a restriction has struck a balance in ensuring national security. Now, this restriction can ensure that people cannot engage in activities that will undermine national security. And as I said, they can continue to join trade unions. So there is some safeguard when it comes to the freedom of association. Thank you. I have a question on 17.1a8. That is to allow a trade union to accept a person who is not ordinary resident in Hong Kong to become a trade union member. On the question of not ordinarily resident in Hong Kong, under the immigration ordinance, foreign domestic helpers and workers under labor importation scheme cannot be regarded as people who are ordinarily resident in Hong Kong. Because the definition or the explanation is different. Either you don't use this term or you add a definition in the interpretation section. Registrar, thank you. Not ordinarily resident in Hong Kong doesn't follow the definition of the immigration ordinance. There is no specific definition. It will be construed in the ordinary sense, and that is whether a person in reality is ordinarily resident in Hong Kong. In fact, we have trade unions or foreign domestic helpers, and those members are considered as people ordinarily resident in Hong Kong.
Ms. Maggie Chen, my question concerns page 28 of the Chinese text, bracket 1AA. Those who do not ordinarily reside in Hong Kong, they may become a member of a trade union if they are engaged or employed in Hong Kong. Say a person is studying in Hong Kong and he's at the same time taking up a summer job for 2 to 3 months. According to 17 bracket 1b, the person's membership cannot be rejected. So how will you manage these members? A lot of these members of the trade union, they may be students, but after they've finished their studies, they're not engaged in the trade. So does that mean there will be a lot of members of the trade union who are temporarily students in Hong Kong? Registrar. We are not restricting people from certain trades or industries from becoming members of a trade union. We'll have to refer to the objects and rules of the trade union concerned. A follow-up question. Say there is a trade union and there are freelancers serving as members of the trade union. The member may be over 16, but he is still a student. These students may become part of the executive of the trade union, meaning that the student could become a member in charge of certain decisions of the trade union. A person who is 18 or above can become an officer of a trade union, as long as the person meets the relevant requirement in terms of his age or rules of the trade union. The trade union can set higher standards in terms of who can become a member. That means in a trade union, there could be apprentices or those engaging in summer jobs, serving as members or officers. And the students who serve as members of the trade union after they finish their studies may not stay in the same trade or industry. These students, upon the completion of their studies, if they do not stay in the same trade or industry, they may not be able to represent other members of the trade union. I'm not just referring to the new trade unions in the future. You may want to look at the constitutions of the existing trade unions. Say a member or a trade union may represent a certain trade or industry, and there are members in the executive of a trade union working only as interns but aren't directly related to the trade or industry. Section 17, bracket 1A. Only those with poor health or who have retired may not serve as a member. There might be cases in which students taking up summer jobs serve as members of a trade union. So what I'm saying is that you should review the constitutions as well as statutes of the existing trade unions to avoid such situations. Mr. Kwok Wai-kang. Thank you, Chairman. I'd like to see clarification from the administration on this. Section 17, bracket 1AA stresses that a person who is not ordinarily resident in Hong Kong but is engaged or employed in Hong Kong may be a member of the trade union. According to the administration, it's not adopting the definition of the Immigration Department when it decides whether a person is ordinarily resident in Hong Kong. Here is the scenario. Say an overseas or a foreign seafarer. He is not a Chinese national. The employer signs a contract with the seafarer, but the seafarer rarely works in Hong Kong because the ship travels to other places. Will this seafarer be considered as an ordinary resident in Hong Kong? Secretary, any reply? There are fishermen in Hong Kong who face the same situation. Our understanding of ordinarily residents in Hong Kong is that the person may reside in his hometown, but because of job reasons, the person have to reside in other places. It's hard for us to decide whether the person in your case is considered as ordinarily resident in Hong Kong. We have to look at this on a case-by-case basis. Say a person spends a long time residing in Hong Kong, then the person may be considered as ordinarily resident in Hong Kong. Chairman, if it only concerns a small group of people, say a trade union with just 100 or 1,000 members, this wouldn't be a major problem. What about a company that hires a group of foreign seafarers who form a trade union in Hong Kong, which has nothing to do with the affairs in Hong Kong? Secretary, let us provide a written reply afterwards. It's set out clearly in the bill that the person who is not ordinarily resident in Hong Kong has to be engaged or employed in Hong Kong in a trade industry or occupation with which a registered trade union is directly concerned. I believe most of the trades and industries in Hong Kong, they do not face the same situations like seafarers who travel to many places. Mr. Lai Tung Kwok, followed by Ms. Maggie Chen, then we will wrap up this page. Mr. Lai. Ms. Maggie Chen raised a very good question just now. Say a student is taking up a summer job in a trade or an industry with which a registered trade union is directly concerned. That student may join the trade union as a member. Whether the student should continue to be a member of the trade union after he has finished his studies, well, I think there is an answer in the English text. If you no longer take up the summer job in the same trade or industry, well, you should no longer be a member of the trade union. Let's look at 17(1) and 1A. If a person suffers from poor health or a person has retired, then he or she may remain a member of the trade union. I think this is clear. You have to be directly connected to the trade or industry in order to join the trade union of the trade or industry. This is my view. Secretary, any reply on this? No? Okay. Ms. Maggie Chen. Thank you, Chairman. I agree with Mr. Lai. Say a person is not ordinarily resident in Hong Kong. The person lives abroad, not in the GBA. If the person is engaged or employed in the trade or industry concerned, of course there will be no problems. However, there are so many different types of jobs nowadays. For example, a person completes a project online once every few years, but he is not ordinarily resident in Hong Kong, but he falls under the definition of 1AA. This person has very little connection with Hong Kong, but he can serve as the executive or the manager of a trade union. Is this common? Can this kind of people serve as officers of a trade union? The answer is affirmative. I want to know the Secretary's view on this. I'm not referring to policy matters here, but normally when we talk about people who are ordinarily resident in Hong Kong, we may be referring to those living in the GBA, not those living abroad. Like Mr. Kwok Wai Keung said, there might be seafarers who reside somewhere else. What I'm saying is that there might be a member of the trade union who has no connection with Hong Kong, but he is still in control of the trade union. I raise this question because the trade union may use the fees charged on its members to hold elections. I thank Ms. Chen for the questions. According to the existing legislation, in order to become a member of a trade union, the person must have a reasonable connection with Hong Kong. According to the legislation, the person has to be ordinarily resident in Hong Kong in order to be a member of the trade union. Say the person is a seafarer, and after he's finished his job, he returns to Hong Kong and he resides in Hong Kong, then the person meets the requirement. Trade unions may revise their statutes and constitutions. We have to look at the nature of the person's job. The person has to be employed by an employer in Hong Kong under the employment ordinance in order to meet the requirement. The trade union, where necessary, may accept these people as members. But what Ms. Maggie Chen is that there are people who are not ordinarily resident in Hong Kong and they do not work in Hong Kong, then they do not meet the requirement because they have no connections with Hong Kong. This is our concept.
So the critical point is he must be ordinarily resident in Hong Kong. Mr. Lai Tong Kwok, I think Ms. Maggie Chen was very meticulous. But if we look at Section 17.2, it's made very clear. Without the consent in writing of the registrar, no person shall be an officer of a registered trade union unless the person he is ordinary resident in Hong Kong, etc. So under 1AA, if a person is not ordinarily resident in Hong Kong but is engaged or employed in Hong Kong in the trade, industry, occupation, then he can only be a member of the trade union but not an officer of the trade union. If the rules of the trade union doesn't allow the person to do so unless there is a consent in writing from the registrar. So this is very clear. Mr. Kwok-Waker, just a very simple point. Since the Deputy Commissioner responded, I have to respond as well. So if the person is not ordinarily resident in Hong Kong, but is engaged or employed in Hong Kong. Now, if he's employed in Hong Kong but can engaged in work outside Hong Kong, then there is a problem. So if we have one AA, if we do away with employed in. But I think the most important point is ordinary resident in Hong Kong. Perhaps we can ask the Commissioner to explain. Yes, we can think about that, but we believe the current drafting is okay because we have to add someone who is not ordinary resident in Hong Kong, and so he must be employed in Hong Kong. If this requirement is done away with, then that person has no connection to Hong Kong whatsoever. This is our thinking. All right, that's very clear. 17A, page 30 and 31 and 32. Page 31, section 17A. The amendments are textual and technical. Right. Same with page 32. Well, there is a substantive amendment on page 32. On the right-hand side, we added 17A bracket 3, 4, and 5. Under subsection 3, if a person is recharged with a specified offense, but he hasn't informed the registrar, then the registrar may require the person to cease holding office by means of a written notice. Bracket 4. If a written notice has been given and yet is not complied with within 14 days, then the registrar may apply for an injunction to prohibit the officer from holding office. Subsection 5 is to make clear that a reference to proceedings does not include an appeal or review proceedings. Now, if the whole proceedings are not yet complete, the person has to stop holding office until the appeal or review proceedings are done. Law draftsman, we don't have any amendments in the English text only. Okay. Mr. Chow Siu Chong, on page 31. If a person has committed a certain specified offense, then he cannot be a promoter or an officer of a trade union. I noticed that in Form 1 application for registration of a trade union, now we have information required of the preparatory committee, although it is not in the law, but I'd like to know whether such persons would be banned from becoming member of a preparatory committee or a chairman of a preparatory committee. This ordinance hasn't prohibited this, but then in this Form 1A, I'd like to know, Form 1, I'd like to know whether such persons can be a member of a preparatory committee. If there is none, how can you ensure our national security? Registrar. Thank you, Mr. Chow. So we talk about the promoter. The preparatory committee is actually the promoter of the registration of a trade union. So a person cannot be a promoter of a trade union, but then a promoter is different from a member of the preparatory committee. Secretary, re-regulate promoters. There can be at least 7 promoters, although there can be more. So someone who has been convicted of certain specified offense, then he cannot be a promoter. But what if he asks someone who have not committed that offense to be members of the preparatory committee? Now, we have seen preparatory committees with a few scores of members. So long as the person has committed a specified offense, then he cannot be a promoter. Why don't you regulate other members of the preparatory committee as well? Now, there may be people who only play an ordinary role, not that of a promoter. Well, even after a trade union is registered, that promoter may just be an ordinary member. But then what about the chairman of a preparatory committee? If a certain person has committed a specified offense, he can be the chairman of the preparatory committee. Why don't you regulate that as well? Yes, there is the promoter of a trade union and also the executive of a trade union. Now, whether you call it a preparatory committee or preparation committee, whatever you can call it different names, if the chairman of such a committee has been convicted of national security offense, then we don't have to approve it. Although it is not in the law, but there can be different levels of regulation. Now, if there are 7 members in the committee applying for registration, and if we know that someone has committed a national security offense is behind it, we can, of course, reject the application. We will be the gatekeeper. So the important thing is about gatekeeping. Whatever tricks they have, it is important that there is proper gatekeeping. We know that there may be masterminds behind such committees, but I believe the bureau will be aware of that, or the registrar will be aware of that. Okay, if there are no other follow-up questions, we've completed section 17A. We are now on page 33, section 18. All right, let's deal with section 18 first. There are 4 pages. We'll first deal with members' representatives. 17C. Yes, 17C is a new section. That is, members' representatives may vote on matters related to a trade union. Now, when they have general meetings, members are there to vote, and we have new section 17C. We have relaxed some of the restrictions. Members' representatives can vote in general meetings. So, and it applies to section 12C, 23, 33B, 33B, and 45, etc. All right, page 18. Section 18, rules, textual amendments. There are 4 pages, all the way to page 36. Yes? Page 33, 34, 35. There are only textual amendments, and page 36, apart from a textual amendment, we have some substantive amendments. There is new section 1888. What page are you on? Page 36. 7. The penalty has got a textual amendment, and then there is a new provision, 1888. The English text of subsection 8, we have replaced the word shall. What about new section 1888? Please explain. Yes. It is a transitional clause in relation to section 18, and it's also related to schedule 2. Let me explain. Under schedule 2, trade unions, now if they become members of a foreign organization, now in their constitution there must be a provision stating that there must be an article stating that that trade union is a member of a foreign organization. Now we are going to expand that to external, to an organization established in an external place. The transitional provision will then allow all trade unions in existence to not to amend its constitution at once. But for other external organization, if they want to have any connection with these organizations, then amendment of the constitution is required, and there must be consent from the chief executive. So this provision is about the need to amend their own constitution. All right, got it. 18A, section 18A, textual amendments. All right. Law draftsman. No, we don't have amendments in the English text only. Then we go to section 20 on page 38. Textual amendments. Okay. The English text, we've only deleted the word thereof. 39, page 39, section 20A. 20A, subsection 3, a textual amendment. Subsection 4, we've made it clearer. We add a mens rea. So if an officer of a trade union or any person on his behalf who knowingly uses or authorizes the use of a seal. So we've added mens rea. So English text, we've changed the word shall. Section 21 on page 14. Thank you again. This is a textual amendments only. Anything in the English text, we've added the heading and also to replace the word shall. Just a simple textual amendment. Yes.
Page 41. Section 22. Most of the amendments are textual amendments. We are enhancing the penalty here. For English version, we are only amending the word shall. Section 23 covers pages 42 to 44. Mr. Kwok Wai Keung. Sorry, Chairman. Page 41, section 22. I have a question. The provision is drafted to safeguard national security for trade unions that are highly suspicious. We should pay special attention to them or follow up on matters relating to these trade unions in a serious manner. I've got views from individual trade unions. For example, some executive members of a trade union, they aren't very educated and it takes them a long time to prepare the documents, and the fine is now going up from $2,100 to $25,000. How can the administration ease their concerns? Registrar. As we enforce the law, prosecution is our last resort. We normally issue advice and warnings to the trade unions to make amends. Section 22, subsection 3 concerns trade unions that violate subsection 2. That is, the trade unions fail to apply for a change in the trade union's names with the registrar. We normally do not prosecute the trade unions right away. We issue advice or reminders to trade unions first. Now we move on to page 44, section 24. We're adding a new heading here. No pure English amendment? No. Page 45, section 25. A textual amendment. We're revising the term prescribed form to specified form. And we will not need 3 copies, so we're removing that part. Same for English. Pages 46 to 47 concern section 27. There are substantive amendments proposed here. It's worth noting that we are introducing bracket 1 capital letter A. The registrar may refuse to give consent to an intended amalgamation of registered trade unions if the registrar reasonably believes that it's necessary for safeguarding national security to refuse to give consent to the intended amalgamation. There are consequential amendments to section 27, subsection 1D. For subsection 2, there are textual amendments. For the English version, we are amending the word his, and there are other textual amendments as well. Page 47. They are mostly textual amendments. It's worth mentioning that we are adding something new to subsection 3. If the registrar refuses to give consent to an intended amalgamation of registered trade unions under subsection 1, there could be appeal. Refusing applications concern subsection 1A. As for rejecting applications on the basis of safeguarding national security, no appeals will be allowed. Page 48, section 28. Here we propose to repeal section 28. We should look at this part together with section 45 and section 31. The existing Section 28 says that there is an amalgamation application if the trade union concerned is an organization established outside Hong Kong, and for these applications they have to get the consent of the chief executive. We are amending Section 45. Under the amended section, we are going to regulate organizations established outside Hong Kong. Say a trade union has, in accordance with Section 45, applied to become a member of an external organization, then the amalgamation applications made by the trade union will not have to be referred to the chief executive for approval. A merged trade union, if it is to become a member of an external organization, the procedure will have to be handled in accordance with Section 45. That's why we do not need Section 28 under the amended ordinance. Page 49, Section 29. These are some textual amendments. For the English version, we are amending the words shall, his, and thereof. Page 50, Section 30. These are textual amendments. Same for the English. We are amending the words shall and thereof. Page 51. Section 31 and Section 31, capital letter A. We are introducing Section 31, subsection 3 here. A trade union, if it wants to become a member of an external organization, it will have to go through the procedure in accordance with Section 45. Part 4B. Notification in respect of dissolution. We are introducing a new section, 31, capital letter A. Within 14 days after the date of the passage of a resolution for dissolution, the registrar will have to be notified by the trade union. Page 52, Section 32. We are revising 14 days in Chinese text. Bracket 2. It specifies who will be made accountable if the persons concerned commit an offense. For the English version, we are amending the word shall and thereof. I'd like to ask about Section 32, subsection 2C. It says if there is any other person bound by the rules of the trade union to issue or send the notice. Any examples for any other person bound by the rules? Those bound by the rules of the trade union may include paid staff. Page 53, Section 33. It goes all the way up to page 54. Page 53, we are amending the title. Funds, Accounts, Returns, and Records. We are also introducing a new title or heading here, Division 1, Funds. We are amending words such as his and thereof in the English version. Page 55, section 33A. And page 56, section 33B. Well, we are revising the penalty on page 54. Now, moving on to pages 55 and 56. Electoral funds may be used for elections held by the trade unions. We're expanding the scope, covering not just LegCo elections and district council elections, but also election subsector elections as well as CE elections. For trade unions, that commit an offense by breaching the law, they will face a heavier penalty. Page 56, section 33B. There's a textual amendment. For section 33A and section 33B, there is no pure English amendment. Page 57 to page 59, section 34. We're adding section 34, capital letter A here. Restrictions on receiving contributions or donations from external force. Applications will have to be made. And there will be restrictions on how the funds could be used. Subsection 7 states that the contributions or donations made must not be used in local elections. No amendments concern only the English text. Two members have questions. Mr. Chao Xiu-chung. Thank you, Chairman. I have some questions. I hope the administration could address them. I agree that if a trade union is to receive contributions or donations from external force, applications will have to be made to the administration, and how the funds will be used should be stated clearly. My question is, will the procedure be very complicated? I hope the procedure will be straightforward enough. Here, specified forms is mentioned. Say I'll have to give a brief account of the background of the foreign organizations concerned. How detailed do I have to be? And do I have to make an application for each contribution or donation I get from an external organization? Say there might be people with ulterior motives, and I get an organization from the UK making donations to my trade union every day. Will I have to make declarations every day? This is a rather extreme case, but I do want to know whether the government has ways to deal with such situations through administrative means.
The second question is, now if I have applied to the registry and I do not have approval for keeping the contributions now or donations. Now, if there are ways for me to refund it, it's okay. But what if the donations were through ATM machine and there was no clear channel for me to return the donations? So will the money be confiscated by the government? How should I deal with donations that cannot be returned? And if they are not approved by the registrar. What if people donate money to Mr. Charles Trade Union on a daily basis? So you have to seek prior approval. Now, if they insist on giving you donations, you report it to the police. So it is really a trick. It is a malicious trick. So you should not notify us. Rather, you should report the case to the police. So this provision is very clear about receiving donations. So if you have funds unaccounted for in your account, you should report it to the police at once. Mr. Chairman Kong, I agree with Section 34, but I am concerned about the time element. If a donation would like to apply for receiving contributions from an external force, is there any time frame for approval from the registrar? And the second question is, if the decision is to refuse it, and yet the money is there. Under the law, the money has to be returned as soon as possible. But how soon is it? Should it be 1 month, 1 year, 1 month, or what? You cannot receive the donations before obtaining the approval from the registrar. As regards how long will it take for us to give you an approval, I can't tell. If it is very simple, perhaps it will be soon, but if it is a complicated organization, we will take time to investigate. So you must seek the prior approval of the registrar first before you receive contributions or donations. But under the law, you have to return the money as soon as possible. Is there any time frame? In fact, you can do away with this provision if a prior approval is required. Mr. Chow or registrar? Yes. Under Section 34A, bracket 2, if an external force has given contributions or made contributions or donation to a registered trade union without the prior knowledge, then the trade union must make an application to the registrar within 14 days after its officers become aware of the fact, and then it must not expend the contributions or donations. All right. For cases where the donations or contributions were made without the knowledge of the trade union, and then the registrar has refused to give approval, so the money should be returned as soon as practicable. And as for how long will it take for a registrar to vet an application, we undertake to do it as soon as possible, but there is no time frame specified in the law. Of course, I understand that the registrar will consider an application depending on the circumstances of the case. But what about return of the money? You should specify a time frame, 1 week, 2 weeks, or a month. Because if there is no time limit, the trade union may keep the money indefinitely. While you cannot have a time frame for approving or rejecting an application, you should specify a time frame for returning the money, because it may be an offense to keep the money, and you shouldn't allow a trade union to keep the money for a year. So you should require the money to be returned within, say, a couple of weeks in order to live up to your legislative intent. Now, the money has to be put in a separate account. It cannot be used for any purpose, so the money is already frozen. I think it would be more flexible if we say as soon as practicable. If we say within 1 or 2 weeks here, that can complicate matter because a trade union will break the law if it cannot do so within the time frame. We are doing this for the benefit of trade unions. So the meaning of as soon as practicable can be different under different circumstances. Anyway, the money will have to be frozen. It cannot be used to ensure that it will not be used for illegal purpose. So the important thing is the exhibit will be frozen. Mr. Chow, what should we do with the money if it really cannot be returned? Should I donate it to any organization, or should it be confiscated by the Treasury? What should a trade union do with the money if it cannot be returned? Some banks may freeze the money for a longer period of time. Yes, should I just keep it in a separate account forever? I think you should suggest a way of disposal. It can either be confiscated by the government or what? Yes, we can give a written reply afterwards. The trade union intends to return the money, but there is no way it can do it. Then what should the trade union do? We will provide a paper later on this. Now we are on page 60 to 61, section 35, registrar. Thank you. Section 35, most of the amendments are textual, just to make the relevant provisions clearer. In subsection 6, we give a clear definition of specified officer. So section 35 is the treasurer to render accounts to members. So in the English text, we have changed here and thereof. Page 62, 63 to 64, 65. Actually, all the way to page 66. They are on section 36. Yes, this is about the submission of account and returns to the registrar by the trade union. We have added new sections here, such as 1A, 1B, 1C. If a trade union has received contributions or donations made by an external force, it must provide accounts to the registrar. The time frame for submission of such returns and the statement must comply with statutory requirements and in a certain form. There are also textual amendments. Subsection 4 is in relation to the penalty. We have raised the penalty. English text we've changed shall, thereof, and him. All right, page 67. Page 64 to 66, section 36A, registrar. Thank you. 36A, duty to keep records. Here, we provide for the keeping of records by registrar, covering books and accounts, register of members, minutes, and also records of resolutions, etc. Subsection 1 has specified records to be kept, and subsection 2 is about the period for such documents to be kept. Penalty is in subsections 3 and 4. Subsection 5 gives a definition of verifying document. Thank you. Mr. Chow. Thank you, Chair. May I refer you to Section 36A, subsection 3 and 4 on penalties. There is no statutory defense given here. Yes, I have kept records in my trade union office, but what if someone has stolen it, or there's a fire or other forces majeure? Then if there is no reasonable defense or reasonable excuse here as a defense, then this is going to be problematic. What can you do here to allay the concerns of trade unions? For whatever reasons, if the records are there for whatever reason, then it's already an offense. Can you provide a defense here? Anyone from the administration? When we take enforcement action, we will give regard to the circumstances of the case, because you quoted some really exceptional cases. You mentioned special circumstances. They can be given special considerations, and you talked about statutory defense. In fact, under common law, if there is an honest misunderstanding or mistake in good faith, well, it can be used as a defense. Even if we don't have a statutory defense here, the principle under common law can also be invoked. Now, I have considered another piece of legislation. Landlords of subdivided units are required to keep records of utility bills. And then there is this defense without reasonable excuse. And then Cap 612, there are also requirements to keep records, and they have this defense of without reasonable excuse. So why can't you provide the same here? It can be a defense here. It can also be a mitigating factor, because the court will rule that the defendant has breached this provision if there is no statutory defense offered here. Law draftsman. We believe the specified forms are really basic yet important documents, and we only require such documents to be kept for 2 years. This is very reasonable. If a trade union is unable to produce such documents, we will look into the circumstances. If they are really circumstances beyond the control of the trade union, for sure we will not prosecute the trade union. Now, we were supposed to end at 6 p.m. May I suggest that we extend the meeting by 15 minutes, and after that, it will depend on members' schedule. Mr. Lai Tong Kwok.
Mr. Chow asked a very good question. My understanding is that you have to make the Chinese and English versions consistent. In English, you use the word keep. In Chinese, you use 保存. Say, for example, there is a fire for no reasons and the records are burned. Because of force majeure, the records are destroyed. If I set a fire myself and burn the records, then I fail to keep the records. I think we have to look at the fact in order to decide whether the person concerned has breached the law. Page 67. Section 37. Registrar. Page 67, Section 37. We are removing some terms here. This part is about the registry checking the records of trade unions. We're removing some parts because we are grouping them into 8A. And we are introducing new subsection 2 here. The account books and the register of trade unions have to be made public for the inspection of its members, subject to any other enactment and the rules of the trade union. The relevant information should be made available for inspection. Any particular amendments for the English version? No. Section 38, capital letter A. These are some transitional provisions from the existing 36A about what kind of records should be kept. We will draw a line using the commencement date. For example, transaction records before the commencement date will not have to be kept for registers. Trade unions that had ceased to be a registered trade union, they will not have to keep the registers. Page 69, Section 42. This is just a textual amendment. We're amending the words shall and his in the English text. Page 70, Section 44 and Section 44A. Section 43A, we're amending the words shall and his under the section. Sections 44 and 44, capital letter A. We're introducing Part 6A, restrictions on affiliation with organizations in external places. There are some interpretations or definitions under Section 44A. Office bearer. There is a definition for it under this section. Law draftsman. This is a new section, so no pure English amendment. Section 45. There are quite a number of amendments. We are expanding restrictions on registered trade unions being or becoming members of organizations to those in external places. Section 45, subsection 1 is about the restriction. With authorization of members, affiliation could be established with organizations in external places, but for subsection B, the consent of the chief executive will have to be obtained. And the restriction about trade unions not allowed to be a political organization continue to apply. If a trade union violates the notification of continuing with its affiliation with organizations in external places, it would be against the law, and we have set out the penalties here. For the English version, we're amending the word shall. Section 45AA, pages 73 to 75. Restrictions on officers of registered trade unions being office bearers of organizations in external places. Members of trade unions may serve as officers of organizations in external places if they are already affiliated with that organizations, but for those without affiliation, they'll have to obtain the consent from the chief executive. According to this section, if a member of the trade union becomes an office bearer of an organization in external places through lawful means, he will have to notify the registrar. The registrar may serve on the officer in the trade union a notice requiring the officer to cease holding office in the trade union. If the officer concerned does not comply with the notice, there will be penalties. The penalties are set out in subsection 7. We are introducing subsection 5 here. Apart from the penalties set out, say an officer fails to satisfy the registrar by ceasing to act as an officer of the external organizations, then the registrar may apply for an injunction prohibiting the officer from holding office in the trade union. This is a new section, so no pure English amendment. Page 76, section 45A. It goes all the way to page 78. Page 76, section 45A. Transitional provision in relation to section 45. It is an existing provision. There is no amendment. Page 77, again, no amendment. Page 78, we are introducing section 45B, transitional provisions in relation to section 45AA. Under the current arrangement, say an officer of a registered trade union has become an office bearer of an external organization. Within a month's time, the officer will have to notify the registrar. If you are serving as an office bearer of the external organization through which an lawful affiliation has been established, you may notify the registrar. This is a new section, again, no amendment concerning the English text only. Page 79, again section 45B. We have already covered this section. Page 80, section 46. These are mostly textual amendments, and we are increasing the penalties set out here. We're amending the words thereto and therefrom in the English version. Page 81, Section 47. These are mostly textual amendments. We're introducing bracket 1 capital letter A. For the term wife, we are amending it into spouses concerning intimidation or threats. We're also enhancing the relevant penalties here. In the English text, we are amending the word him. I think I touched on this in the previous meeting. For summary conviction, a decision can be made by the authority. For conviction on indictment, you'll have to go through DOJ. It's more complicated. Do you consider it based on which method is more efficient and requires less time? Yes. Section 49. Punishment for withholding money or property of a registered trade union. The district court may give a fine or order a fine. Words such as himself or thereof are amended in the English text. I extended this meeting by 15 minutes. If you all agree, we can extend the meeting by another 15 minutes so that we can finish the clause-by-clause scrutiny. Thank you for your understanding. I think no other committees or panels are going to use this meeting room. We have finished section 49. Pages 84 to 86. Section 50. We are enhancing the penalty here. We're also introducing Section 50A, furnishing false or misleading information. There are no pure English amendments in Section 50A. Page 86, Sections 51A and 51B. We're adding Part 8A here about enforcement powers. 51A, interpretation of Part 8A. There's a definition for authorized officer. The entire Part 8A from Section 51A to Section 52, they are all new sections, so there aren't any textual amendments concerning just the English version. Page 87 and page 88, Section 51C. This is to empower the registrar to conduct inquiries. Under the bill, certain information will have to be provided to the registrar, and there are penalties set out here as well.
Law draftsman, any amendment? None. So, Section 51D and E. Section 51E to Section 51F from page 89 to 91, Registrar. 51D, powers to require verification explanation. So we can require the trade union to make a statutory declaration or response. Section 51E, use of incriminating evidence in proceedings. 51F is about offenses in relation to destruction of documents and information, with the penalties here. 51G, powers of the registry to enter premises of trade unions. The penalty are in Section 92. 51H, powers to enter and search premises with warrants. And also the relevant penalties are also here. Any amendment to the English text? No. Mr. Charles Siu Chung. Thank you, Chair. Premises and also the residence. How do you define that? Is it based on whether it is inhabited or whether the building is industrial building or factory building or a commercial building? Registrar. It depends on whether the place is being used as a residence. Well, even if it is a residential building, but it is a place, is an office, then it can still be regarded as a non-residential premises. So if it is in a commercial building and yet there's a makeshift bed and they tell you that somebody resides here or I live here, so will you then define it as a residential premises? Then it must be reasonable and legal. That's why I asked you, how do you define it? Now, if it is a commercial or industrial building, it cannot be used for residential purpose. I think the registrar is saying that for many trade unions, the registered address is a very old residential building. And there may be people living there, they may not. I have visited these places, although it is ordinarily a residential building, and yet the place is registered for the trade union office. So even though the building is a residential building, but the place is mainly used for an office purpose, then we can regard it as a premises of the building. All right. 52. Thank you. If a trade union contravenes our rules, then the registrar can issue notices. We have widened the scope. Originally, the title was contravention of rules. Now we have made it a bit and is for contravention of objects or rules, and we have also raised the penalty. No amendment to the English text only. Okay, page 96, section 53. Yes, we have relaxed 56 bracket 1C. Now, right now, approval by all of the officers of the registered trade union is required for additions to membership of trade union federations, but now we've changed it to majority, and we've also changed the penalty. For subsections 53 and 54, the amendments are to the English text only, textual in nature, change in terms like thereof, shall, etc. Okay. Page 97, or rather, page 100, section 57. Again, this is to make it clear. A person convicted of a specified offense cannot be an officer of a trade union federation. We've changed the word here, amended the word he. All right, page 101, section 58. Textual amendment also, from forms and offences to specified forms. In subsection 3, because the penalties here are no longer needed, we have made major amendments because we have section 58, so we are going to scrap section 58.3. We do not have pure English text amendments. All right, that is rather simple. Section 59, page 102 and 103. We do not have any amendment on page 102, and on page 103, if a trade union contravenes any of the provisions on registration, the maximum penalties are now raised. Again, we do not have any pure English amendment. All right. Section 60, page 104. Again, textual amendments. This is about the functions. We do not have any amendment to the English text only. So this is a textual amendment. Page 105, section 61 and 61A. Thank you, Chair. Liability of officers. So we have clarified under what circumstances can a defense be invoked. In 61A, we have the standard of proof for defense. Section 61, we have amended thereof, thereunder, and shall, and section 61A is a new section. There is no amendment to the English text. So 61A, we have standard of proof for defense that echoes a point made by members earlier on. Page 106, section 62. Thank you. We have a new section 62 to set out the prosecution deadline for summary offences. It is 2 years here. We do not have any amendment to the English text only. All right. I'd like to know whether 2 years is a common prosecution deadline compared to other offenses. Usually for summary offenses, the deadline is 6 months, and we have made it a bit longer here. It's 2 years. Noted. Thank you. Page 107, section 63. Thank you. It's about serving of a notice. This is to clarify what is meant by serving a notice. We do not have any amendment to the English text only. All right, page 108, section 65, textual amendment. English text, we changed words like shall and him. Page 109, section 66. We have added circumstances under which notice should be given in the Gazette. So this is when the registrar has appointed a manager. The English text, we change the word shall. 68 is just a textual amendment. No change to the English text. And page 111, any supplement? We have page 110. We have a substantive amendment. Officers specified for the purposes of section 17.2a and 3. 17.2a, national security offenses, and then another part is specified offenses. Section 68. The amendments are just done to the English text. Schedule 1, none. So Schedule 1 is to supplement what was in the previous provisions. Page 113, 114, 115. Shall we go through it page by page? First, 113. Textual amendments only. We have scrapped D1 because under the Trade Union Ordinance, we have provisions on keeping of records. So there is no need to have this clause in Schedule 2. The others are textual amendments. We do not have pure English amendments here in Schedule 2. All right, you have covered Schedule 2 in one go. 114 and 115, any explanation, Registrar? On page 114H, we have added members' representations in voting, and H3C, because we have amended Section 45 to regulate the membership of foreign trade union federations. And page 115, again, textual amendments. (116) and 117. 116, subsection 2. The register of a trade union must be signed or initialed by the registrar for each and every amendment. Now we have relaxed it a bit, so long as it is approved by the registrar or public officer authorized by the registrar in any manner. Okay, page 117. Now, we specify the number of copies required. In future, only one copy will suffice. We have already deleted references to copies. We have changed the word therein here. All right. I'd like to know whether the approval can be done by email or what, apart from signing. Now, for instance, a file may be submitted to me by colleagues, and a certain application has already been approved. It can be regarded as an approval. There is no need to sign or initialed. Okay. Next. Page 114 and 119, Registrar, also textual amendments. We've simplified the number of copies required, etc. The schedule is usually simpler. We've changed shall and his, and Section 9 is a new amendment and also textual amendment. What about 10? We have changed the word shall. Page 120, 121.
This is a textual amendment regarding how many copies will be required. We're amending words like shall and him under Section 11, and no amendments concerning the English text only under Section 12. Say if the certificate is lost, will a fee be charged? Well, you may consider charging a fee. People are forgetful and they may lose the certificate. While I work for organizations myself, and you may want to charge a fee on the organizations if the certificate is lost. Page 118 and 119 of the Chinese text. These are all textual amendments. There are no amendments concerning the English text only under section 13, and we're only amending the words like his and shall for the other section. Page 120, textual amendments only. Page 121, again textual amendments only. Under section 16, we're amending words like shall and thereunder, and for section 17, there are no amendments concerning the English text only. Mr. Lai Tong Kwok. Thank you, Chairman. I understand why the administration is amending section 17, subsection 1. According to the existing provision, a fine of $10 each day will be charged if a person continues to contravene the regulation. So it will only be $100 for 10 days. Will the administration give a second thought to this part? Chairman, we will give a written reply. It looks like $10 is too little. We will give a written reply. I thank the member for the reminder. Mr. Lai is correct. If the fine is too low, people may continue to contravene the law. I understand that most people are law-abiding, though. Thank you all for attending this meeting till the end. We have scrutinized the 121-page bill. Let's see if the legal advisor has anything to say about the English version of the bill. Thank you, Chairman. On the English text, the LSD has looked at the English text as well as the Chinese text side by side. Like the administration said, there will be CSAs for members' consideration. As to whether there will be any legal or drafting issues concerning the CSAs, once we've received the CSAs, we will scrutinize the amendments and will notify members of any spotted legal and drafting issues. Thank you, legal advisor. Let me consult members on this. We have finished the clause-by-clause scrutiny of the bill. We will circulate the following documents to members. They include the administration's consolidated written reply to the issues raised in this meeting. Also, on the response made by the administration in this meeting as well as the CSAs to be proposed by the administration, they will be circulated to members. On CSA drafts, if members intend to make proposed amendments, and if you would like the Bills Committee to consider the proposed amendments, please, as soon as possible, send the amendments to the Secretariat. The deadline for making the proposed amendments is the 23rd of May, Friday. I also ask the administration to submit the CSAs to the Bills Committee as soon as possible for members' consideration. Any other business? I thank all of you for attending this meeting till the end. We have overrun. We scheduled another meeting, but I don't think we need to hold another meeting. There being no other matters, meeting adjourned. Thank you.